Court rules on remote versus in-person learning for children of two teachers. This time of year we see lots of let's change little Johnny's school motions. The COVID-19 pandemic has added a new and an unfortunate twist to what is already a common battleground of disagreement between separated and divorcing parents. A slight variation on this theme was seen in a decision recently released in the fall of 2020. School session is set to begin. As outlined briefly, is this a medical decision or an educational decision? This case involved two parents, both of them who happen to be school teachers, who were at odds over whether their children should attend in-class schooling, as the father wanted, or learn remotely from home, as the mother strongly preferred. They went before a court for an urgent ruling, the mother asking to be granted sole decision-making authority over the issue. The children were currently 6 and 8 years old, and were slated to attend the same school to enter grades 1 and 3 respectively. After reviewing the facts in detail, the court ruled that, at least for these particular children, their best interest dictated they should learn remotely, online, from inside the mother's home for the duration of the fall 2020 semester. The court prefaced its conclusions with these observations. The policy of the provincial government is that in-person school attendance is optional for the 2020-2021 school year. If parents decide they should not return to the physical classroom, remote learning is available. This flexibility allows parents to make the best decision for their family. However, this model breaks down where the parents have separated and are not like-minded about their children's best interests. That is the case for these children. The result for them over the past weeks has been ambiguity, confusion about their return to school, plus increased conflict between their parents on the heels of what already is many months of riddled with change and uncertainty. There can be no doubt that the school environment offers children social, physiological, and developmental advantages. The question here is whether those benefits outweigh the potential risk of returning to that environment in the context of a two-household family. The court took stock of all the pertinent facts relating to each of the parents and their current living situations. This included the mother's 15-month-old child with her new common-law partner, who had underlying medical conditions and was immune compromised to the point of being off work. In the course of concluding that the balance favored remote learning for these children, the court said it took notice of information widely repeated in the public domain that very young children are likely to be at higher risk to their immature immune systems. A return to in-class learning brings increased risk of exposure to COVID-19 and, in turn, increased risk of transmitting the virus to vulnerable family members. It is the risk that the court found unnecessary for this family at this time. The children are good students and surrounded by trained educators in both households to help them if needed. The mother will be in the home every day until at least late January 2021 to guide and supplement their online learning. The court was also satisfied that both parents are attentive to the girls' needs for social interaction, social learning, and physical exercise. For those reasons, the court found the children's best interest to attend school virtually for the 2020 fall semester and was to do so from their mother's home. The father is away from the home during the day, and other members of his household are working, either from home or away from the home. The court concluded by adding an important admonishment to the parents, encouraging to make every effort to resolve this issue quickly and focus on reducing the conflict between them, especially as the children return to their studies and grapple with the many challenges and changes that the world continues to present. The court urged the parties to consider the most sensible schedule for the children in context of all their needs and interests. The children deserve nothing less. So what do you think? Did the court get this decision right? You can like and share this video. You can subscribe by clicking the bell. You can comment at the comment box at the bottom of this video, and we're going to endeavor to answer everyone's questions at the end of each week. Until next time, stay safe, and I'm Russell Alexander.